Good morning. Thank you all for coming. My name is Jesse Grauman. I am a Director of Policy Development and Programming for the American Constitution Society for Law and Policy. On behalf of ACS, it's my pleasure to welcome you all to our Supreme Court review for the 2013-2014 term. ACS was founded in 2001 and is a national network of lawyers and law students, practitioners and policymakers, judges and academics who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on critical legal and constitutional questions, such as those we'll be hearing about today. The decisions the Supreme Court has issued this term, and those it has yet to issue, span a wide variety of areas touching numerous aspects of American life, from the influence of money on our elections to reproductive rights, to the scope of executive power, to the future of organized labor, to digital privacy, and many, many other issues. And we look forward to hearing the insights of a fantastic panel of experts here this morning. Before I turn things over to our panel, I just wanted to invite all of you to visit our website, www.acslaw.org. Our website includes our blog, ACSblog, which contains analysis by scholars, advocates, and others on a variety of legal issues. And it also includes ACS's issue briefs. We have some sample issue briefs here today, although I understand they've all been taken. They include one on religious exemptions for corporations, which is one of the issues in the Supreme Court's Hobby Lobby case you'll be hearing about. One on the constitutionality of the Voting Rights Amendment Act, on which a hearing was just held in the Senate earlier this week. One on the association rights of employees and the Knox and Harris cases, which you'll also be hearing about, and as well as an issue brief studying the behavior of Supreme Court justices in the most critical cases. And so since they're all the paper copies are all gone today, please feel free to visit our website at acslaw.org and download those and many others. It's now my pleasure to introduce our moderator, who is one of the foremost authorities on the Supreme Court today, Tom Goldstein. Tom is a partner at the firm of Goldstein and Russell, and he has served as counsel to the petitioner or respondent in about 10% of all of the court's merit cases for the past 15 years, personally arguing 31 of those cases. Tom is also the co-founder and publisher of SCOTUSBlog, a blog devoted to coverage of the court and the only blog ever to receive the Peabody Award. Yesterday, during the Supreme Court's release of opinions starting at around 10 a.m., there were nearly 20,000 people following the live blog at SCOTUSBlog, including me and including, I'm sure, many of you as well. Tom has also taught Supreme Court litigation at Harvard Law School since 2004, and he previously taught the same subject at Stanford Law School for nearly a decade. Please join me in welcoming Tom Goldstein.
Thanks so much. It's wonderful to be here with you on the almost review of a Supreme Court term to tee up the last little taste of the court's decisions, which will come down on Monday. I know I speak for all of the panelists that we're incredibly grateful to each of you for taking time out of your day to come and visit with us and have a conversation about the court's term, obviously a shared subject of interest for everybody in this room, and also to C-SPAN and the audience that's watching there. The format is as follows. I'm going to just give just a touch of background about the term to give some context of other things that are going on. Then we're going to turn to the big cases of the term, including the two cases that are left to be decided. We're going to really assume a fair amount of knowledge on your part because this is a self-selected group of folks who know a lot about the court. And so we're not interested in telling you kind of here are the facts of the case, but we want this group of experts who we're so lucky to have here to talk about the implications of the case, what might come next, what the surprises are, and things like that, to delve into analysis. And we're going to go through, probably the top 8 cases of the term. We're going to stop about 20 minutes before the end of our time together. We have an hour and a half in total to answer your questions. So just a touch of background. This is a term that's gotten a lot of notoriety, not only for some of the big cases, though maybe we don't have same-sex marriage or Obamacare, but there are important decisions, obviously, that we're going to talk about, but also the unanimity of the term. And we can talk about whether or not it's true, or as Justice Scalia said, phonymity in the court. But it is striking that there's going to be the lowest number of 5-4 decisions this term in the court's modern history. I think there'll be 10 in the end. There'll be somewhere between 8 and 10. That's less than half the number of the last term. The ideological lines drawn by those decisions are not classically the 5-4 ones by and large. Obviously, we have 2 more cases to go that can change things, but right now there are 2 with Justice Kennedy in the majority with the left and 2 with the right. Justice Kennedy has been in the majority of all of them, and he probably will be in the majority in the opinions that come down on Monday as well. The court has fewer dissenting opinions than any time in its modern history this term. There seems to be something afoot, an effort by the court to try and come together, even if it's just nominally in the result and not in the reasoning. So it shouldn't hide the fact there's still significant disagreements on the court. So with that, just little context for the term, let's turn to the big cases, and let's start with privacy. Elizabeth Wydra is chief counsel at the Constitutional Accountability Center, which has really emerged as an incredibly important voice in the court on structural constitutional questions, really major constitutional issues of the day. The Riley and Worry cases about cell phone privacy involved two different cell phones. One was a flip phone and one was a smartphone. And the question was, when these people were arrested, did the police have the right to search the phones incident to arrest without going and getting a warrant?
Yeah, thank you, Tom. It's great to be here with you and with this great panel and with all of you here today and watching on C-SPAN. It was a really interesting decision, and I will say that it was a truly unanimous decision. It wasn't one of these phone-animous decisions that we're going to talk about later. And what was really interesting about it was the court issued a very broad and sweeping ruling in favor of Fourth Amendment protections, in favor of the privacy of the information that people keep on their cell phones. For those of us who were at oral argument, it seemed as if the justices were playing around with having a possible middle ground. So you have the concerns of law enforcement, which want to look through your cell phones, your smartphones, and go through that incredible cache of information and try to find evidence of a crime. And at the same time, the interests that American people, that the individuals who live in this country have in protecting those vast stores of information. As the Chief Justice noted in his opinion for the court yesterday, the information that we keep on our phones is quantitatively different, of course. We have this technology to keep vast amounts of information. Back at the time of the founding, you would have to lug around a padlock trunk with you if you wanted to keep even just a fraction of the correspondence, records, et cetera, that we can now keep in our pockets. And it's also qualitatively different. You can get a much broader picture of a person's life, their private information, from all of this information we keep on our phones. And so the justices played around at oral argument with sort of middle grounds of balancing those interests, whether it would apply to, whether you could have exemptions for the police to look through a phone if someone was arrested for a very serious crime as opposed to, sort of not wearing your seatbelt. And what was interesting about the decision yesterday is that the court unanimously rejected all of those middle ground positions and went for a very broad ruling that says that even if you are arrested, which reduces your privacy interests a little bit according to court precedent, even if you're arrested, if the police want to look through your phone, they have to get a warrant. And the only exemptions are these very limited sort of emergency exemptions. So, for example, if the police have reason to believe that you might use your phone to detonate a bomb remotely or something like that. These emergency exemptions. So it was a very broad ruling, and that was surprising. And it was unanimous. Justice Alito wrote separately just to emphasize the fact that what the court was essentially saying, and this I think is one of the very important parts of this ruling to keep in mind, is that the digital age changes the way that the Fourth Amendment applies to certain devices. And essentially what the ruling yesterday said is that computers and computer-like storage devices are different. And I think we'll see the Fourth Amendment applying differently to those sorts of devices. And that was why Justice Alito wrote separately to note this fact explicitly and say that there could be anomalies that result. So in the past, if you had a wallet in your pocket that had some of the things you might some analogous things to what you might find on a phone, photographs, maybe a note from your spouse or something like that in your wallet, the police could look through it. But now if something in your pocket is your smartphone, or if you have a laptop in your backpack, then the Fourth Amendment might apply differently. You might have greater privacy protections because of the types and the amount of information that we keep on those sorts of devices. So I think the broadness of the ruling was something that was surprising and is really important. The recognition that in the digital age, the Fourth Amendment might apply differently to certain methods of storing information than we've seen in the past. That is another, I think, really interesting point from the ruling. And I think in terms of implications, one of the things that will be interesting to see is whether the government, sort of both federal and state, step back from some of these more aggressive positions that they've taken with respect to being able to access information stored electronically. I wouldn't really expect to see them walking back. I think maybe there'll have to be several more cases in which the Supreme Court says that the Fourth Amendment applies robustly to digitally stored information. But this did seem to be a clear signal from a unanimous group of the justices saying that the Fourth Amendment applies robustly to this sort of information, whether it's stored on the cloud, whether it's stored on your phone, whether it's stored on a computer or your iPad. I think the implications are that the Fourth Amendment will apply very strongly in that case. And I think there's one other point that I want to make with respect to this case, which is there's been a lot of talk, especially in progressive circles, about how you want to avoid taking cases to this particular Supreme Court because it's difficult to win progressive victories. And one of the areas in which we've seen the Roberts Court sort of taking what might be called somewhat liberal positions are areas in which there's sort of a liberal-libertarian alliance. So we saw in the Defense of Marriage Act case, the court striking down that provision. And in this case as well, both my organization, the Constitutional Accountability Center, which is a progressive organization, and the Cato Institute were on the same side of this case. And similarly in the marriage equality case, we were on the same side. So I think that one of the ways in which you can see progressive outcomes from this court is in these sort of libertarian types of cases where you're talking about individual liberty. So that's interesting. And then I guess sort of my last point that I would make on the case is that, you know, I personally was really interested to see Chief Justice Roberts, in his opinion, sort of analogize the privacy interests that we have and the desire to keep private the information on our smartphones to the founders' opposition to the British use of general warrants, which this is a way that they could break into your house, search, go on a fishing expedition for incriminating information. And to analogize those, I think, showed that the court really gets that these privacy issues, when it comes to this most personal information that we carry around in our pockets with us every day, really resonates with the American people. So I think they were trying to show that they were with it, both technologically and sort of spiritually with the American people.
I was just going to say that one of the themes of the term that these cases fit into involves the court struggling with technology, particularly computers. In some of the cases we're not going to talk in depth about today, Aereo, the big copyright case, big patent case involving abstract ideas being turned into computer programs. You saw the court at oral argument being very nervous about not sure they understood the technology and afraid that they might do something to interfere with the technology. Of course, in the Fourth Amendment case, by saying that these devices are protected, they didn't have to worry about causing any harm to the technological development. But it is an interesting phenomenon. The court, I think, is going to continue to have to face new technology every term.
I think one of the themes we're going to see throughout this morning is that where the justices are familiar with something, they are more likely to have a view of it that is different than when they are not familiar with it. And there's a lot of legal jargon in this case, a lot of technical Fourth Amendment analysis, but the bottom line is all 9 justices have cell phones. All 9 justices understand that their lives are in their cell phones, as many of you are doing right now, and all 9 don't want the police searching their cell phones. And we can talk legal mumbo jumbo all day, but I think that's what's going on in this case.
I think Elizabeth made a great point in what was the phrase you used, liberalitarian. I think that one of the most interesting phenomenons I think we've seen over the court, maybe the last 30, 40 years, is what I would call the evolution of the conservative instinct. If you go back 30 years, the conservative judicial instinct was largely a statist instinct, a thumb on the scale of the government instinct. We saw that in its rulings upholding statutes. We saw that most prominently in the criminal sphere. I don't know if I'd call it a sea change, but a dramatic change in the modern conservative judicial instinct, which is much more of a libertarian instinct. And we again see that in the criminal sphere in cases like this. We see it with a conservative judicial mindset that's much more willing to strike down laws that it perceives as being regulatory overreach. We see it, I think, maybe most prominently also in the First Amendment sphere. Remember, 30, 40 years ago, many conservative jurists didn't believe that commercial speech was protected by the First Amendment. That was a position that was largely advocated by the liberal wing of the Supreme Court. Today, we've now seen almost a flip-flop, where conservatives are the most robust embracers of that kind of commercial speech protection.
Just to put 2 points together, it is a little hard to look at the Chief Justice's opinion and think about things that they see in the newspaper or are very familiar with, and this notion of a libertarian instinct, and not hear echoes of the discussion of the NSA metadata program and the collection and aggregation of all of that information. So it'll be very interesting to see the impact of the decision there when it eventually comes up. So Noel Francisco is the head of the government relations practice at Jones Day, Reeves & Pogue, also an experienced Supreme Court litigator, which made for the perfect combination in dealing with a historic case about the relationship among the branches of government, the Noel Canning case, which he successfully argued and won yesterday. Noel Canning, you all are very likely familiar with it. Just the 2 seconds of backdrop. The president recess appointed during so-called pro forma, during a recess that was interrupted only by pro forma sessions, several members of the NLRB, which were essential to give the NLRB a quorum. That was an expansion of a historic practice of making recess appointments under the president's recess appointment power under the Constitution, and it gave rise to a significant challenge. The D.C. Circuit had invalidated the recess appointments on a couple of grounds, and the Supreme Court asked for a briefing on yet another ground, and had a very significant decision on the scope of the recess appointments power.
Sure, and if you'll forgive me, I'll do a little bit of chest thumping because we're very proud of the result that we achieved in that case. And in our view, this was a resounding 9-0. There was difference in reasoning, but a 9-0 rejection of what we consider to be a very abusive use of the recess appointment power. And I think it underscores what in my mind is the important role that courts play, particularly when it comes to separation of powers. And another trend that I think we've seen in this context over the last 10 years or so, where the court is much more willing, across party lines, across ideological lines, to restrain excesses in executive power. We saw that in the context of the war on terror and the assertions that the president was making there. We've seen it carry through to President Obama's assertions of a similar type of executive power, albeit in the domestic context. And one of the problems that you have in the political process when it comes to assertions of executive power is that you always have a president that is interested in expanding executive power. It doesn't matter whether the president is a Democrat. It doesn't matter whether the president is a Republican. That president is always interested in expanding executive power. On the congressional side, you always have a constituency that is going to support the president, because the president's party will generally be supportive of the president's assertions of executive power, even if it were a different party president making the same assertions, those members of Congress would be taking a different position. So what you have is a dynamic that leads to an ever-increasing expansion of executive power, because you've got a president that always wants to expand it and a Congress that is kind of wishy-washy on it. Some of them are in favor of it at any given time, and some of it against it. That's why it's so important to bring the judicial branch into the fray whenever possible, because it's the only neutral arbiter that's willing and able to enforce the lines that the Constitution draws. Brings us to the Noel Canning case, where it exemplifies this expansion. In my view, Justice Scalia's concurring opinion was correct on the original understanding of the clause. But more importantly, I think what it reflects is that over time we'd seen the president gradually expand the recess appointment power. Their first expansion was very early on, when they asserted the authority to make recess appointments to any vacancy, as opposed to those vacancies that happened to arise during the recess. Early presidents rejected that, but shortly thereafter, other presidents embraced that power. The Senate essentially, there was some back and forth, but as the court found, the Senate didn't vigorously oppose, and in some sense maybe acquiesce. But there was still this other limit. It can only be exercised in between sessions, so-called intersession recesses. That gets us all the way to around 1921, where we then see the executive branch jettison that limit. and assert that it can make recess appointments during that period as well. So we saw another dramatic expansion of the power. But even then, as we saw at the end of the Bush administration, presidents acknowledged that the Senate had substantial control over its own process, and so it could still prevent recess appointments if it actually convened sessions every 3 days so that it didn't take any substantial break during which an intra-session recess appointment could be made. And then finally, we saw President Obama with these recess appointments jettison even that limit, essentially asserting the power to make a recess appointment at any time to any vacancy, including when the Senate was actually convening sessions, albeit short ones, albeit ones that were likely designed for the primary purpose of preventing recess appointments, but they nonetheless were sessions. When it gets to the courts, I think what we saw was a resounding rejection of that assertion and that expansion of executive power, not really that different from what we've seen in contexts like the war on terror. There is a difference of approach that the majority took and that the concurring opinions took. The majority took what it would characterize as a much more pragmatic approach, where it said, yes, we're going to tolerate these first two expansions, these two historical expansions. There's just too much water under the bridge at this point to overturn that. But we're going to recognize that the Senate has control over its own calendar, and if the Senate says it's in session, and if the Senate's capable of conducting business during those sessions, as it was here, that's the end of the game, and we're going to say that they're in session, no recess appointments. The concurring justices took much more of an originalist view. They studied the text and original understanding of the Constitution, came to a different conclusion on the first two historical questions. But I think the point I want to leave you with it was that, in my view, the debate between the majority and the concurring justices is largely an academic one. It largely goes to how many past recess appointments are going to be called into question. Going forward, I think any of either the majority's rule or the concurring justices' rule largely returns the power to where it belonged in the first place. That is, the power of advice and consent to the Senate. Because even under the majority's rule, the Senate, or in fact the House as well, has the ability to prevent recess appointments if it wants to. So the president will be allowed and enabled to make these recess appointments only if the House and the Senate actually agree and allow him to do that by not convening these so-called pro forma sessions. So while there is a huge difference between the majority and the concurring justices in terms of their approach to the law, in terms of their reasoning, and in terms of the bottom line rule that they adopt, I don't think there's a lot of difference in terms of the practical impact that the rules that the different sides advocated would have going forward.
Yeah, so I guess I don't want to rain on Noel's parade at all. I guess I just want to throw my own mini parade, is what I'm saying. So my reaction to the ruling was that it was not as bad as it could have been for those of us who supported the constitutionality of President Obama's recess appointments in this case. And that's because of this difference between the Justice Breyer opinion and the opinion that would have been controlling if the more conservative justices had held the day. And I think that what's important about the difference between those opinions is that it does preserve a very core aspect of the recess appointments power. And the court refused to go down the road that the DC Circuit took, which was this much more radical interpretation of the recess appointments clause that would have prevented presidents from making appointments during intra-session recesses and for vacancies that arose prior to that recess. And so I think the fact that the court didn't go down that road is a really important aspect of the decision that sort of has been not focused on as much, and instead is seen as, the decision has been seen as sort of a rebuke to the Obama administration. And I would also point out that this is not something that the Obama administration invented. As has been noted, presidents from both parties have used this power, although I'm sure Noel would say that this use of the power was a step more than other presidents.
But I would say what President Obama did invent was the use of recess appointments to circumvent so-called pro forma sessions. Though the Senate convened under Majority Leader Reid pro forma sessions during the Bush administration for the express purpose preventing President Bush from making recess appointments. President Bush, whether he agreed or disagreed, I don't know, with what the Senate was doing, but he honored what they were doing, and he never attempted to make a recess appointment while the Senate was convening pro forma sessions. President Obama's innovation was to jettison that one last remaining limit on the recess appointments power. And that, frankly, was the principal argument we advanced in the DC Circuit, the pro forma session issue, and we were the ones that asked the court to add the pro forma session question to the cert petition when the government tried to take it up without that issue in it. We've always believed that what was particularly wrong here was the context in which these recess appointments were exercised and the unprecedented nature of it. In our case, it always focused on that unprecedented nature. That's why I really do believe that this decision was a direct rebuke to that overly zealous assertion of executive power.
I guess one thing that stands out about this, though, is when we talk about this from the academic perspective versus the practical perspective, which is, I am always thinking about the academic perspective. And I find this decision particularly interesting in terms of, what we would talk about as a formalist perspective versus a functionalist perspective. But when you're looking at the function of this decision going forward, there is the question about whether, practically speaking, if you have a president in one political party and a Senate majority in another political party, what the future of recess appointments are.
Or a House majority of the other political party.
Yes.
Because the House likewise can prevent recess appointments by refusing to allow the Senate to adjourn for more than 3 days and hence requiring pro forma sessions.
Right.
So that's why I think that the practical distinction between the rules is not all that great. Mm-hmm. Whenever one party controls the presidency and the other party controls either house of Congress, that other party has the ability to trigger pro forma sessions and prevent recess appointments. The only time that you wouldn't have that dynamic is when one party controlled all three branches, both houses of the Congress and the presidency. But that's precisely when you don't really need recess appointments,
right.
Particularly now that there's no filibuster for presidential appointees.
I'd like to make one comment about Justice Scalia. May not be the last one today. His excessive rhetoric in his concurrent/dissent in this case, which is typical of his excessive rhetoric in separation of powers and federalism cases generally, is, I think, really ironic, because he ignores 150 years of tradition, however you count it. He ignores that. He will not ignore that in the prayer case, for example. But here's the thing. Justice Scalia's approach to constitutional law in separation of powers and federalism cases is completely different than his approach to individual rights cases. And if he were here, he would be yelling about law, law, law. But the difference between his separation of powers perspective and his individual rights perspective is one of values and experience and living his life, not law. And I think I would love to ask him that question, why he treats separation of powers cases so differently than individual rights cases.
And Tom, only because I clerk for Justice Scalia and I love the man, I do have to step in and defend him. I don't think there's any difference. I think he is, if you look across all of the areas of law, he is a very, very much a strict originalist, and that takes him to results that sometimes align with his political views, and it sometimes takes him to results contrary to his political views, as demonstrated by his ruling upholding the right to burn a flag in Texas against Johnson. I can assure you that that's not consistent with his political views. But wherever he lands, I can guarantee you that he lands there passionately. And you can find cases in the most mundane areas where he is in dissent, and you may think the world is ending because the majority went the other way. That's his personality. But I don't think it reflects any difference or any inconsistency in how he approaches different legal issues.
I need a one-sentence response. His Ralph Cramden approach to passion, I agree with. Listen, affirmative action, takings, the 11th Amendment, these are all areas, and Shelby County, where he adopted a completely unoriginalist approach to constitutional law. So this American myth.
That is the longest sentence.
Yeah.
It's like semicolons and commas and dashes. Few ellipses. I'll put two things on the table and then we'll move on. They point in opposite directions. One is, does the recess appointment power matter after the nuclear option? So if you have the president in the same party as the Senate majority, well, then the nominee is going to get confirmed. If the Senate is not in the same party as the president, then the nominee is going to be rejected anyway. And it has been the case that presidents haven't made recess appointments for nominees that have been rejected. That could change. So it may be that Noel Canning, though a very significant constitutional principle, may not have a ton of practical impact. The second is that while Noel thinks, and also Erich thinks, that the difference between the majority and the concurrence is not a big deal. I have written today that I think that's wrong, and that the art of Justice Breyer's opinion, whether on purpose or not, may well be that the president can evade the restriction that's in the majority opinion, because it depends on the idea that no senator will object to the existence of a quorum. I know Noel disagrees with it. We don't have to debate the merits of it, but there is an open question about its consequence. Okay, Leah. Leah Epperson is a professor at my law school, the Washington College of Law, an expert in constitutional law and many other things, runs the SJD program there, and in particular is an expert on issues related to race and the Supreme Court. We did have one really important race-related case this term that has kind of gotten buried and lost in the shuffle. Maybe it was decided a little bit earlier, but it tells us a fair amount, I think, about where the court is at on these questions, and it relates to some other cases that you can discuss, I'm sure. The Schuette case involved a Michigan constitutional amendment in which the voters of Michigan announced that they were going to change the Constitution to forbid affirmative action, including particularly race-based affirmative action in higher education and some other things. And that had the consequence, effectively, of overruling a prior Supreme Court decision that had said the University of Michigan's law school could take race into account as a factor in admissions. And so the court was presented with the question of whether the state's voters could essentially ban affirmative action in that fashion.
Mm-hmm. And so you're exactly right that this is sort of following up from the opinion 11 years ago, the Grutter decision that was upholding the constitutionality of race-conscious admissions at the University of Michigan. What's important to keep in mind is that it is technically not an opinion that's about affirmative action in education across the board. So it does nothing to alter the constitutionality across the board of those kinds of policies. So it hasn't changed the holding of the Grutter decision 11 years ago. That said that under the Equal Protection Clause, colleges and universities could create narrowly tailored race-conscious admissions programs. There was also probably the opinion that got maybe a little bit more publicity last year, Fisher versus University of Texas, because it was decided at the very end of the term, that was looking at the constitutionality of the University of Texas's admissions policy, which included a race-conscious component. This is an opinion in a case that's really more about an issue that relates to civic participation. So it's about access to self-government, and this particular proposal, Proposal 2 in the state of Michigan, is a voter initiative that does have the effect of eliminating the affirmative action program at the University of Michigan. This is a 6-2 decision. Justice Kagan recused herself. And I think depending on one's perspective, you could look at it in a variety of different ways. These types of initiatives, one of the big questions, and something that was actually very eloquently discussed in Justice Sotomayor's lengthy dissenting opinion, was what it means to ensure meaningful political participation, and whether it means that one need only remove formal barriers to participation, or whether it includes a responsibility to vigilantly police the political process to ensure that all minority groups have equal access to participate. On the ground, a Proposal 2, a ballot initiative and a constitutional amendment like the one in Michigan, effectively means that there is a higher burden placed for those who would advocate for having a race-conscious admissions policy. So if one is in favor of race being one of a number of factors that are considered in admissions policies, one would need to basically overturn a state constitutional amendment to do so, a very, very high burden. If, however, you are a major donor to a university and you want to give a thumb on the scale to your kids, if you are an alum and you want to give a thumb on the scale to your kids, if you're an athletic officer and you want to spend time promoting star student athletes to go to public universities in the state of Michigan, you can continue to do so. So all of those other forms of what are essentially affirmative action still stand. The one that has been removed and singled out is the consideration of race. And I think what one can think about with respect to what that means long-term is, again, it does not touch the merits, the constitutionality of race-conscious admissions policies across the country, but because this has been raised to the national level, because there is a spotlight on this, and because those who advocated for this type of ballot initiative in Michigan were successful, I think that it does signal and can signal to voters across the country, if there are others in other states, and there have been, who would like to push for similar measures as the one in Michigan. The Supreme Court decision has given them really sort of more fuel to their fire to be able to do so. So I think that's one of the long-term consequences of something like this. Another thing to keep in mind is that there have been instances in which the Supreme Court in decades past has examined similar types of ballot initiatives that would single out particular minority groups to make civic participation in certain areas more difficult. And in those instances, the Supreme Court has struck those down. So there are ones relating to, for instance, in Seattle in the 1970s around busing, in the city of Akron, one that's a very common one that most all constitutional law professors teach, Romer versus Evans, which dealt with an amendment to the Colorado Constitution that had singled out gays and lesbians and said that under the Colorado Constitution, no state jurisdiction could create any policy that would protect gays and lesbians from discrimination. And the Supreme Court in Romer versus Evans held that you cannot single out a particular group based on animus and make it more difficult for them to participate in the political process. So there were some who believed this was very much akin to that kind of reasoning and therefore should be struck down. It was struck down at the lower court, but the Supreme Court reversed that. And so for those who would be in favor of the ability to continue these kinds of programs in a state like Michigan, there have been those who look to Justice Sotomayor's opinion as very interesting in terms of having a voice, a minority voice, well, no pun intended, both a racial minority on the court, but also obviously a dissenting opinion as opposed to a majority, that spoke very frankly and passionately about the role of race in the United States and the important role that the Supreme Court plays in needing to take account of it. And so she actually referenced Chief Justice Roberts' opinion in a voluntary racial integration case dealing with elementary and secondary schools that came out, I guess, 7 years ago now, where he said that the way to essentially end race discrimination in America was to stop talking about race. And Sotomayor said the way to address racial discrimination in America is to speak openly and candidly about the role of race, about continued barriers to opportunity so that we can move forward.
Slight tweak on what the Chief Justice said. I think he said end racial discrimination on the basis of race by stopping discriminating on the basis of race, not stopping to talk about race. I don't think he's ever suggested we don't need to talk about the issue. But on that case in particular,
I would actually beg to differ with that piece of it. I think you're right that he said, I apologize, that he said to end discrimination, but I think wrapped up in that is a desire to stop talking about race.
Maybe. But on that case in particular, though, I kind of go back to, I think it was the Ninth Circuit that addressed this issue or a similar issue about 20 years ago. And one of the lines that always stuck with me from that opinion was the Constitution does not require what it barely permits. We've had a very heated debate over whether racial considerations can be taken into account. And I apologize for this.
It's very relaxing.
Yeah.
No.
No problem.
We have had a very...
Do that for the Roberts Court.
Yeah.
I thought I turned this off, but I guess I didn't. We've had a very heated debate in this country over whether race can be taken into account in school admissions and in other areas. And the Supreme Court has resolved it, albeit narrowly. But it's a whole huge another step to say that in addition to being permitted to take these factors into account, you're required to take these factors into account. That, to me at least, is a pretty extraordinary proposition, and I think that's why you saw that decision not being one of these strict 5-4 decisions, but even Justice Breyer coming across to acknowledge that basic principle, that at that level, once you get to the level of whether you should take it into account, rather than whether you can take it into account, that is really a decision that should be left to the political process.
Well, can I just clarify one point
Sure.
there, though? You said whether they should be required to take race into account, and that's not what the opinion is about. That's not what the case is about, or Proposal 2. It's a proposal that eliminates the ability to do so, but it's not. The question was never, should they be required to take race into account?
Yeah, I mean, perhaps, but I actually think, though, that it really does boil down to that. Can you say that you're you're not allowed to not take it into account because the political process decided that it didn't want it to be taken into account.
All right, so let's turn to religion. Something less controversial. Erich Segal is a prolific author and expert on the court, having published all over the place on major constitutional questions that the court is confronting, and is also working now as a co-author on a path-breaking book on Supreme Court transparency. And is going to talk about religion for us. The first of the religion cases, the town of Greece, in which the Greeks, the Grecians, the folks in that town started their town council meetings with an invocation, which they thought was akin to a legislative prayer. It was overwhelmingly a Christian prayer based on who it is that they happened to invite, and there was a constitutional challenge that was an establishment of religion.
Elizabeth said that progressives, or people who were in favor of Obama's recess appointments, the Noel Canon case, didn't lose as badly as you thought you might. People who are in favor of separation of church and state lost as badly as they possibly could have. There was no greater loss we could have suffered than this case. 8 years in a row. Prior to 1999, the town of Greece, New York, started its very small town council meetings where you would go if you want a zoning variance, or if you want to argue about the local cable access channel. You have to conduct your business there. This is not a big state legislature. This is not the Congress. This is a small town council. And prior to 1999, they began their meetings with what I think is an incredibly appropriate way to start their meetings, a moment of silence, where everybody could pray or not pray, reflect whatever they wanted to reflect on. Starting in 1999, and for 8 consecutive years, and I am sometimes prone to hyperbole, but in this situation, I'm not. 8 consecutive years, 100% Christian prayers. No exceptions for 8 years. And 2/3 of those prayers referred explicitly to different kinds of religious symbols, and in many cases, the chaplain of the month, which is what it was called, yes, the chaplain of the month, would ask the audience to stand up or bow their heads in prayer to Jesus. As a thought experiment, I kind of wondered if I stood up here and asked you to do that, what the reaction would have been. And this isn't even a government meeting. But in any event, the Supreme Court said that was not an establishment of religion, 5-4, partisan divide. Justice Kennedy, and when I say flip-flopping, on this one, he did about 17 flips, given that he is the author of 2 opinions that say that prayers in public school classrooms, prayers at high school graduation ceremonies and prayers at high school football games are unconstitutional, even non-denominational prayers. So he really did flip-flop here. And I want to make just 3 points. First, 8 years in a row of exclusively Christian prayers. This was a situation where the Supreme Court upheld a clear preference on the part of the government for one religion over all others. I don't think there's any other Establishment Clause case where the Supreme Court has done that. There are parochial school aid cases where neutral statutes had a disproportionately beneficial effect on Catholic schools or Jewish schools. But those were neutral practices with disproportionate effects. This was 8 years in a row of Christian prayers. So for the court, and even Justice Rehnquist, before he left us, said that the core command of the Establishment Clause is the government cannot treat one religion over another. And that's exactly what the town of Greece, New York did. So that's very significant, I think, in terms of doctrine. Even more importantly, whether you look at Justice Kennedy's opinion for Justice Roberts and Alito, or Alito's separate opinion, or the concurring opinion of Scalia and Thomas, all of them read the Establishment Clause out of the Constitution when it comes to legislative prayer cases, and even more scary, other cases as well. Because, Justice Kennedy gave examples of when legislative prayer would violate the Establishment Clause. And almost all of them would violate the Free Exercise Clause. There's 2, we're going to get back to this with the Hobby Lobby case, but there are 2 commands in the Constitution: the Establishment Clause, the Free Exercise Clause. One says the government can't reward religion too much. That's the Establishment Clause. One says the government can't coerce or penalize religion. That's the Free Exercise Clause. And I think the balance is we want religious liberty, but not religious supremacy. Well, in this case, Everything Justice Kennedy said would violate the Establishment Clause would also violate the Free Exercise Clause, and nothing else. So if you're going to bring a new case challenging legislative prayer, then you're going to have to, in effect, make out a Free Exercise Clause violation, a coercive. Kennedy said if the government took action against you because you refused to pray, that would be an Establishment Clause violation. Well, no, that would be a Free Exercise Clause violation. So I think doctrinally, if this case extends to other cases, the Establishment Clause is in deep trouble, which is consistent with Scalia and Thomas's long-standing quest to end Establishment Clause cases altogether through the standing doctrine, which they have tried to do. But it's not Justice Kennedy's quest. And it's even more ironic because in the last paragraph of the opinion, Justice Kennedy says that the kids had to go to this Greece Town Council as part of high school civics programs. So kids were in the room here when this was happening. Last point, I have 1 more minute. Last point is this. We have a solution to this. When we talk about affirmative action, when we talk about abortion, when we talk about campaign finance, I have opinions, but those are really hard questions. And I don't know the answers. I have opinions. I have an answer for this. And it's the same answer we've used for high school graduation ceremonies, football games, and classrooms. Have a moment of silence. I've been in football stadiums and baseball stadiums of 60,000 people after a national tragedy, where a moment of silence is a really powerful thing. And it works. And it brings all the good things about prayer into the room, but none of the controversial things. So if you want a prayer over a moment of silence, what you're saying is you want to inject religion into the government, and I think that's what the Establishment Clause forbids.
I guess my take on that case is I do agree that from your perspective it's a pretty resounding loss. But what I call it is the triumph of originalism, but good for this ride only. What you see is Justice Kennedy's opinion taking an originalist approach, and there I would argue that it's different from Noel Cannon because you have an unbroken understanding of the application of the Establishment Clause dating back to the time of the founding and after, that these types of prayers were permissible. But on the other hand, the way that the court approached it was that its holding was solely based on legislative prayer, and the fact that there was, with respect to this one type of practice, a long and unbroken chain of history. So yes, while it is a resounding loss for your side, I don't read too much into it. I don't look at it as a case where the principles are going to be translatable to other cases. From my perspective, would that it were so. But
that
I don't
rationale
have
would
that
have
same
upheld
fear that you have.
segregation and discrimination against women. We had segregation in this country forever. We had discrimination against women forever. And if we're just looking about history, those two practices would have been upheld, and none of us want those practices upheld.
And if you look at the way that Justice Kennedy often approaches these kinds of hot-button issues, he often adopts a method of reasoning that achieves the result that he thinks is the right one in that particular case, but that is easily distinguishable when you get to the next one. And I think that's the same kind of approach you saw him take in this case.
We got one clue about whether or not there'll be kind of a doctrinal leak outside legislative prayer to other Establishment Clause questions when the court was asked to consider, right on the heels of this case, another school case where it was a graduation ceremony held in a church. And just the court declined both to take up the case, but also to have the case, which had struck down the practice, reconsidered by the Court of Appeals. And Justice Scalia wrote an opinion saying, I don't understand, I thought we just undid a whole bunch of Establishment Clause jurisprudence in this other case, which I was so excited about 5 days ago. So it was some suggestion that it isn't going to be a revolution. Paul Smith runs the Supreme Court and appellate practice at Jenner and Block, having done a bunch of cases at the Supreme Court as I think the acknowledged kind of leading advocate in a number of fields, the First Amendment, which we're going to talk about today, voting rights, also gay rights issues. We're going to, as I said, there are a couple of important First Amendment cases. Let's talk about the McCullen abortion protesters case, where Massachusetts had passed a law that created a 35-foot buffer zone in front of abortion clinics, and there was a constitutional challenge and a real question about the fate of an older precedent which had upheld a floating buffer zone in front of abortion clinics.
Right, well this was a really interesting outcome because the court unanimously held that the buffer zone was unconstitutional. Going into this case, after the argument, I think no one would have predicted a unanimous ruling one way or the other. The prior case, Hill versus Colorado, that had allowed a floating buffer so you couldn't approach somebody without their consent from more than 6 feet, was extremely controversial on the conservative side of the court, and Justice Scalia continues to find it so. His dissent in this case yesterday says we continue to have an entirely different First Amendment applicable to abortion rights situations than anywhere else. And I think there was a real scenario under which Hill versus Colorado would have been thrown out, and the whole world of how you regulate access to abortion clinics and protect people from harassment and from overcrowding and the kinds of problems that arise in front of these clinics could have been drastically changed. But instead, what you see is a 6-3, really unanimous, but there's a majority opinion in which the Chief Justice gets 6 justices to write an extremely narrow opinion throwing out the law. What's that? Alito, Thomas, and Scalia, right? And Kennedy. Oh, okay, so I'm wrong. So I stand corrected. Anyway, there's majority opinion in which the liberals join with the Chief Justice, and he goes out of his way to say there is no content-based law here. Strict scrutiny does not apply. There were strong arguments made that any law that applies only in front of an abortion clinic is content-based by its very nature. And any law like this one, which allowed abortion clinic employees to enter this zone that was this safe zone around the front of the clinic, while not allowing other people to go there, was content-based because they could come out, accompany people into the clinic and say, you're going to be fine, this is a good place for you to be. Whereas the individuals who were challenging it couldn't do what they wanted to do. And just to be clear, what they wanted to do was not scream at people. What they wanted to do was approach people politely, engage in quiet conversation, hand them some literature, and say, there are alternatives, would you like to hear about them? I'd be happy to talk to you about them. And in the end of the day, the entire court was willing to say that kind of conduct on a city sidewalk is protected by the First Amendment, and we are not going to allow the city to fence off a large chunk of real estate on a sidewalk from people being able to walk up to people, engage them in conversation. Now, the floating buffer zone still exists, can exist, is still the Constitution, but this larger fencing off of this large area is no longer permissible. And I think it's an interesting situation to wonder how this came about. You know, I think that you could easily, as I said, have found a decision where the usual ideological breakdown, but instead, clearly there was an effort made here to bring the court together. Some may call it phonymity, but it is quite a remarkable difference than what we've seen in recent years with the court on these kind of hot-button issues.
I mean, you could call it phonymity, or you could call it what Justice Scalia called it in his, concurring opinion, which is an apparent and specious unanimity, which were really strong words to come from, especially someone who was concurring in the judgment in that decision. So I think it sort of fits into this theme that we're seeing with some of these cases where there is an apparent unanimity. I probably would leave out the specious. I'm not Justice Scalia with his high rhetoric, but it masks the heat, I think, of the divisions in some ways. In that case, I think is an example of it.
Well, it's an interesting case that sort of fits this discussion we had before about libertarians, because there are lots of liberals who are on both sides of this issue. And on the people at the ACLU, we had a very tough time with this issue. And so, I mean, this is not an area in which the natural breakdown occurs. If you have a libertarian instinct, whether you're on the left or the right, you may very well agree with the court.
Paul, I was a little uncertain in how narrow the majority's reasoning actually was when you looked at the narrow tailoring reasoning, because at least as I read it, that narrow tailoring reasoning could apply equally to the floating bubbles. If the primary purpose is to, for example, ensure access, right. What the court said was that you can ensure access more narrowly by prohibiting obstruction.
Right, well, but it's important that they maintain the idea that you can have laws applicable only in the abortion clinic setting. That by itself, according to the conservative members of the court, would have invalidated any law that required strict scrutiny. And so that principle, that this is a particular problem which the state is allowed to address in a less restrictive way, is an important thing to maintain. Exactly how it'll play out in terms of what options are available, the majority suggests some. It is true that you could make an argument that Hill has been implicitly overruled. I believe that Justice Scalia said that. But that may or may not play out that way. And certainly there is much more room to maneuver for people trying to solve this difficult problem of protecting people's right to avoid harassment and get into these clinics than one might have imagined election would be true looking back a few months.
Judge Posner late yesterday, I think, posted an article in Slate that I hope everybody reads, because he characterizes the majority opinion, and the legal question is hard, but the majority opinion's discussion of what women are faced when they go to Planned Parenthood clinics to exercise their right to choice. The majority said, mild persuasion. That's not what happened. And Judge Posner said, what they face are signs saying baby killer. And I would just recommend Judge Posner's Slate article yesterday on this topic.
Yeah, one interesting example of whether or not these opinions mask real problems under the surface that are going to have to eventually emerge is that the majority opinion doesn't even say anything about what happens to the old Hill precedent that was potentially on the chopping block. Just, we're not going to talk about it. Come ask us later.
Well, clearly some strong efforts made to bring everybody onto the opinion who might not otherwise have been there.
Yeah. Elizabeth, let's, and we're going to need to kind of do the remaining cases in relatively efficient form, but an incredibly important nonetheless, campaign finance decision, Mccutchen, following on a lot of attention to the court's campaign finance jurisprudence about the constitutionality of the aggregate contribution limits, not the $2,000 you might give in a particular election cycle, but the amount that you might give to all the federal candidates in total.
Yeah, so I think we can deal with that very quickly by taking Erich's suggestion and having a moment of silence for campaign finance regulation in general. Because while this was just a case about the aggregate contribution limits, it seems that the Roberts Court has yet to meet a campaign finance regulation that it actually likes. And one of the ways that I think the case is important in general for campaign finance regulation is the way that the court, in my opinion, redefined the government's interest in preventing corruption in our democratic system through campaign finance regulation. And so in cases going back to Buckley versus Vallejo, we saw the government's interest being described as preventing actual corruption, sort of its quid pro quo bribery, as well as the appearance of corruption. So sort of any sort of pernicious influence that money in politics might have that undermine the public's faith in the integrity of our democratic system. And so what I see the majority doing in the Mccutchen ruling is sort of really taking out that second part of the government's interest in preventing corruption, and instead really just limiting the government to campaign finance regulations that can be directly tied to the prevention of actual quid pro quo corruption through money in politics. I think that that's wrong. I think that it goes against the understanding of corruption dating back to the founders' understanding of what the government would have an interest in legislating when it comes to preserving the integrity of our democratic system. I think that Justice Breyer, in his dissent in Mccutchen, did a good job of raising that. I think that if you read the brief that I filed on behalf of Lawrence Lessig, Professor Lessig has done really great research on this, showing what the founders understood corruption to mean. So I think the implication is, what does this mean for other campaign finance regulations? Does it mean sort of the end of any limits on soft money? What does it mean for state campaign finance rules? Could it eventually lead to striking down those most basic direct limits on giving money to candidates? I think that all of those are fairly open questions at this point. And I think finally, one point that I think is relevant to think about when we look at the Roberts Court in general, is sort of when you contrast with the Voting Rights Act case last term in Shelby County, where the court also, I think, limited the government's interest in protecting the right to vote. And for those of us who supported the robustness of the Voting Rights Act in that case, it was disheartening to see Chief Justice Roberts' opinion in Mccutchen sort of start with this ode to democracy, in which he sort of laid out all the ways in which you can participate, from casting your vote in the ballot box to contributing money, and sort of seeing the Roberts Court making it easier to give campaign cash, but arguably harder for people to cast a free and fair vote at the ballot box.
I think that you're right. This is part of a long line, not long, but relatively recent line of cases by the Roberts Court, revisiting a lot of these campaign finance cases. To me, I've always thought that these were relatively simple cases. You're talking about core political speech made at the single point in time when it's most important in the midst of an election. And if you can restrict core political speech at the most important time that it is to make it, that is during an election, and say that during these periods there are restrictions and you can only spend so much money using your voice, then you really are having the federal government directly influence the political process through restrictions on free speech. And the basic principle, in my view, has always been we're better off with more speech. Let everybody scream as loud as they want at one another, spend as much money as they want on that speech, and let the chips fall where they may. So I applaud what I would consider the Roberts Court's approach to all these campaign finance regulations.
Let me just recommend that people look at Justice Breyer's dissent, which I think very articulately tries to lay out the case for the other position, the position that is being still maintained by 4 justices and may someday come back around, I think, because it has so much to say. Recommend it, which is, and what he did is he said, we're going to take this appearance of corruption rationale that's been upheld, but I'm not going to completely reject this other idea that's been out there for all this time, which is you can't level the playing field. And he basically brought those two arguments together and said what this is really about is maintaining democracy and a government that's responsive to the people, and that in a world of billionaires spending billions, there will not be a government responsive to the people, and at some level there has to be a sufficient government interest to maintain some responsiveness.
All right, so let's make sure that we cover the 2 cases yet to come, but we obviously have to wait and see what the outcome will be. Paul, you argued the Harris versus Quinn case, just to frame it up for folks, and the good news they should expect on Monday?
This is a First Amendment challenge to the agency fee that is charged by public employee unions against people who don't join the union but are benefit from the collective bargaining and from the grievance procedures that are used. And it started as a challenge to a specific kind of unionization, which is home care workers who work in individual homes and are paid by Medicaid to do that. The state of Illinois allowed them to be unionized by majority vote. They, as a result, got much better benefits and training and health care and everything than they had before. But some of the people who were in that bargaining unit disagreed with being unionized and having to pay the agency fee, and the National Right to Work Committee brought this as a challenge, which is now kind of morphed into a much broader challenge to the whole Abood line of cases, which say there's nothing unconstitutional about requiring people to pay money to a union for those core union services, not for other things the unions do and say, but for those core union services. A challenge which was kind of invited by the majority of the court 2 years ago in the Knox case, and we'll find out on Monday. Tommy announced on the blog yesterday that we're not going to win, so I guess we'll see whether Tommy knows. But this is one of those counting the justices' opinions from January in exercises. I have other theories, but we'll see.
What's the prediction on who's writing based on that analysis?
Justice Alito.
Okay.
Yeah, who wrote the opinion in Knox saying...
Yeah, no, he's not a vote we're counting on in the case. So
Well, he could just write a kind of sarcastic majority opinion saying that he was wrong. Eric, the important Hobby Lobby case?
Yeah, I guess I'm just going to cut right to the chase here. As everybody knows, Hobby Lobby is a for-profit, privately held corporation that doesn't want to comply with the requirements in the Affordable Care Act that they provide certain forms of contraception to women through their health care, to their health insurance. And this is what I want to say about it. Neither the Free Exercise Clause nor the Religious Freedom Restoration Act, which is the federal law that they're suing under. This is not a constitutional case, theoretically. But neither one has ever been really interpreted and should not be interpreted to allow people to say, I'm not going to follow that law because it hurts my conscience to do so. That is not what those provisions are about. The government should not get in between you and your religious practice. When you when you go to church, wearing a yarmulke, using peyote in a religious ceremony, wine at communion, when the government interferes with those practices, then the government should have a compelling interest, at least under RFRA. I wouldn't have passed RFRA, but it's there, so I accept that. That's not this case. The owners of Hobby Lobby are not doing anything in their religious capacity that the government is interfering with. Hobby Lobby is not having prayer meetings. That's not what this is about. They don't want to comply with a valid secular law applicable to everybody because it offends their conscience. And if we live in a country where people cannot follow law because their conscience is offended, then we're going to have a whole lot of chaos. And other than one evenly divided summary affirmance by the Supreme Court, I don't think the Supreme Court has ever suggested. In fact, Justice Scalia suggested exactly the opposite in the Smith case, that you don't get to not follow the law because of conscience. You just don't get to do that. And that's what the owners of Hobby Lobby want to do. Personally, I hope they lose. One last point about this. Justice Kennedy and the majority said to those people in Greece, New York, if you're offended by 8 years of Christian prayers, get over it. That's what he said. Well, I think what we should say to the owners of Hobby Lobby is, we're sorry you're offended, but you are part of civil society and you have to comply with this law.
When Nadine Strawson testified in favor of the Religious Freedom Restoration Act, one of the examples she cited for why it was important was that absent a protection like the Religious Freedom Restoration Act, you could make doctors who are opposed to abortion perform abortions. Doctors performing abortions are not doing that in their religious capacity, they're doing that in their capacity as doctors. So I don't think there's any colorable argument that the Religious Freedom Restoration Act simply protects you exercising religious things. What it says and what it does is it prohibits the government from requiring somebody to do something that their religion tells them that they're not allowed to do unless it has a really, really good reason and does it in the most narrowly tailored way, subjects it to strict scrutiny. So that's the question here. And here, the owners of Hobby Lobby, much like many Christian or Catholic owners, have a religious and moral objection to doing things that in their view facilitates access to contraception. Their religion tells them they can't provide that insurance plan. What the court has always said is that if somebody tells me that their religion tells them they can't do something, it's not a court's role to second guess that decision. The only question is, does the law in fact tell them to do something that they say they're not supposed to do? I think here it's pretty clearly undisputed that it does. And then you proceed to the strict scrutiny analysis. So I don't think, with all respect, I don't think your description of the Religious Freedom Restoration Act is at all accurate. It is meant to protect against precisely this type of thing. And one final point, there is no law that puts forth the contraceptive mandate. The Affordable Health Care Act says nothing about the contraceptive mandate. That is a Health and Human Services regulation. That regulation, like all other regulations, is subordinate to the Religious Freedom Restoration Act, which is a law. And the Affordable Health Care Act explicitly said that nothing in that act was overriding the conscience protections that are found elsewhere in federal law. The most prominent of those conscience protections is the Religious Freedom Restoration Act. So I don't think that there's any argument that you're being exempted from a law. In fact, you're following the law by applying the Religious Freedom Restoration Act, which is incorporated into the Affordable Care Act.
The text of the Religious Freedom Restoration Act does not refer to conscience. It refers to the free exercise of religion.
No, it refers to a substantial burden.
No, but
religion.
first it has to burden the free exercise of religion, and we have Justice Scalia in Smith, and we had the case in the 1890s on polygamy, and we have generations of cases saying that you do not get to exempt yourself from generally applicable law because your conscience, as opposed to your practice, is affected.
And the Religious Freedom Restoration Act overruled Smith.
But it also says it incorporates the pre-Smith law. The purpose of it was to bring in all of the pre-Smith law, and there is no Supreme Court case prior to Smith that would suggest...
So when Mr. Thomas was hammering out tank turrets, what the Supreme Court held that not giving him unemployment benefits because he objected to hammering out tank turrets, was he exercising his religion when he was hammering out tank turrets? Of course he was. Because that would have required him to do something that his religious beliefs forbade. That's exactly what's going on in the Hobby Lobby case.
Although I think important to note is that, while I have no doubt that the Green family and the Hahn family as individuals might have that similar sort of objection, the law doesn't actually place any burdens on those people as individuals. It places an obligation on the corporate entity, Hobby Lobby or Conestoga would, that if it chooses to offer employer-sponsored health plans, then it must provide the full range of FDA-approved contraception. And so I think that the individuals don't have a claim to bring, and I think that the corporate entity upon which there is actually the requirement doesn't have a claim to bring, because never in the history of free exercise law has a secular for-profit commercial entity ever been understood to share in the protections of free exercise.
And preventing unintended pregnancies is a compelling interest.
All right. Fantastic. now that we all agree.
Just so we're clear, the answer to that one is no.
Okay. Let's be sure to take time for questions, which we think are very important. So we will start with folks, in case any of the folks from the press have questions, and then be sure to reach out to everybody else. And someone will bring a microphone to you. And if you'll identify yourself and then direct your questions to whomever.
Mike Doyle to the panel. Could you return to the smartphone search case? There was brief reference made to the potential implications for challenges to metadata collection. Could you walk through how those challenges in light of Riley will now play out?
Well, I think that, first of all, I think Riley shows that there is a different approach that might be taken to electronically stored information. I think also, and so in that respect, I think that that's important. The majority noted that in response to some debate at oral argument, that protections would probably also apply to information that is stored in the cloud and not just physically on your phone. So that, I think, is an important aspect of the ruling. Also, there was a gesture made to sort of what people call the Mosaic Theory under the Fourth Amendment, that when you aggregate information, when you have, so this came up a little bit in the GPS case, Jones, from a few years ago, that there's sort of something different about aggregating massive amounts of data that gives a fuller picture of someone's activities and someone's life than just sort of picking out. So, for example, in the GPS case, the court found there to be, or didn't find there to be, there was a difference between sort of a detective following someone and only getting the information from, a couple days, as opposed to the sort of information that you could get if you had a GPS and could get this vast amount of information. And so while it wasn't obviously expressly decided in Riley, there was sort of a gesture to the idea that the massive amounts of information contained on a smartphone could be qualitatively different because of the bigger picture that they could give about a person's activities or information. So people who support the idea that that makes a difference saw something to be hopeful for, that the court might adopt a Mosaic Theory in future cases.
I'll add just two quick things, and that is, every Fourth Amendment case has two parts. Is there a search of something that's private? The cell phone cases are about the is it private part. And on that score, the Supreme Court looks back at an old case involving pen registers back in the early days of phones, where the court had said, collecting that information doesn't implicate the Fourth Amendment, and says that precedent really doesn't apply with any substantial force in a digital era when so much information can be gathered from things like phone calls. But there's an important footnote in which the majority says we're not deciding what constitutes a search. And so if the government is able to just collect information about us that's otherwise available from databases and the like, it may not implicate the Fourth Amendment. But actually, collecting phone call information without a warrant will raise serious Fourth Amendment issues.
I was just going to say, it's really more by analogy that the two issues are related. The analogous issue in the metadata context is the validity of the old rule that if you let information be in the hands of other third parties, you don't have any Fourth Amendment claim when the government comes and gets it from the third party, which Justice Sotomayor has suggested in the GPS case is something we need to rethink in a world where everything that we do and think is in the hands of private third parties. But I would think that this is a case that would indicate that those who think that rule needs to be overruled, including Judge Leon here, have some support.
Other questions?
Mike Lindenberger with the Dallas Morning News. I was curious about the liberal-libertarian sort of nexus. You see that a little bit in the politics side too, with Rand Paul and the war on drugs, et cetera. But I think the First Amendment may be the best fulcrum to talk about that. It seems like what used to be sort of a rallying cause for liberals is now often challenging liberal politics in support of the First Amendment, like, for instance, the abortion case. I just wonder if you could talk a little bit about that, the shift and the new maybe newfound support for First Amendment as a weapon for the right, and maybe something that makes liberals less comfortable than they used to be?
Yeah, I certainly, I'm not going to comment on whether it makes liberals less comfortable than they used to be about it. I doubt it does, but I certainly do think that on the conservative side, over the decades, you have seen a much more robust embrace of First Amendment principles along these libertarian lines. I spend a lot of my time in private practice litigating commercial speech cases, and that's where I think we've seen a dramatic change in the court on its approach to commercial speech. Right now, when we're looking at cases, and you try to look across the country at which courts are the best to bring commercial speech cases in, frankly, the Supreme Court is more protective of commercial speech, in my judgment, than any of the lower courts in the country.
I would suggest that writing a check from a politician in Alabama to California is not core political speech at all. And I would also agree with you that the right side of the court has taken the First Amendment away from dissenters. I mean, really one of the major ideas of the First Amendment was to protect dissent. That's gone. And when we have dissenters, in fact, the court doesn't really protect them very well. I think that's a big change.
I think, on the liberal-libertarian alliance, I see it actually less in the First Amendment context and more when it comes to equality and liberty, and as well when it comes to privacy in the Fourth Amendment context. There's been sort of Rand Paul and Chris Coons wrote an op-ed about the Riley case together. In the marriage equality cases, my organization and Cato have filed a joint brief together, as we did in the Supreme Court cases from last term. I think the First Amendment actually is an area in which the Roberts Court has moved the doctrine in a very conservative direction by, some commentators have called it sort of the Lochnerization of the First Amendment, using the First Amendment to strike down corporate and commercial regulations.
Just a brief question looking forward to the panel on death penalty and Eighth Amendment jurisprudence. Does the panel expect anything forthcoming in the next term, or is there anything percolating its way up, or anything from any major circuit decisions, especially in light of the recent issues with experimental drugs for executions?
So the Supreme Court, there's been this debate that we all know about and problems with the administration of the drug cocktails. And so far it has stayed away from stepping into those cases. It has issued a stay in a case from the Eighth Circuit that is going to the en banc Eighth Circuit that isn't so much about the safety of the protocol that was administered, but whether you could impose this protocol on somebody who had very specific health conditions. And I think that the justices are hopeful that that question will go away. Most of the death penalty Eighth Amendment action, I think, is in structural cases that interest Justice Kennedy about mental disability, about age, eligibility, those sorts of things. It has tried to avoid what they would regard, I think, as micromanaging the precise drug cocktail because it's so up in the air and so uncertain. What drugs the states can use. Oh, sorry.
I wanted to ask, in Hobby Lobby, I think what the court does in Hobby Lobby will really be more important for what it says about the court's thinking about the nature of what a corporation is than it will immediately regarding religious rights on a question. And I think they're quite likely to overrule Lord Cook and say the corporations really do have souls. But I'd invite the panel to comment on that broader general question.
I have a colleague who I'm going to shamelessly plug, named Dan Tucker, who is a corporation law professor who is writing about all the implications of Hobby Lobby for corporate law, because we're all focused on the constitutional law. And she's written a lot, and I don't understand it all, but she's very afraid that if Hobby Lobby comes out in favor of corporations having free exercise rights and not limiting it to privately held companies, that a lot of corporate CEOs are going to have very difficult ethical problems going forward in what kind of decisions they make if they have to worry about their shareholders and their employees free exercise rights. And I can't go into more than that, but she's very worried about that, and I think she's right to be.
You know, one interesting thing about that question, I actually think it's an incredibly important question, and I think it's, from my perspective, the most interesting part of the case, but it didn't actually get a lot of play at oral argument. You know, the court was much more focused on the burden, the compelling interest, narrow tailoring. So, you know, what that suggests for how the opinion is going to come out, maybe that means that that wasn't controversial and there's going to be, if not unanimous, then a larger number of justices thinking that corporations can bring these claims. I don't know, but I personally found it interesting and I guess disappointing that it didn't get more of an airing at oral argument.
I just want to add that I think the corporation issue is a lot more nuanced than just do corporations have religious freedom rights. I think most would agree that some corporations do. For example, churches are incorporated entities, and churches clearly have free exercise rights. Well, what about religious nonprofits like Catholic Charities? I think most people would agree that Catholic charities can exercise free exercise rights that are protected under RFRA. So the question really is, why is it that what is it about the corporate form that allows one category of corporations to exercise religious freedom rights and not another category? It can't simply be that religious freedom only attaches to individuals, because we know that's not the case. Rather, we need to come up with, if this is your position, you need to come up with something that distinguishes a corporation that has an expressly religious purpose, like a Catholic Charities, like an archdiocese, versus a corporation that, albeit organized for a for-profit purpose, is owned by deeply religious people who use the corporation to promote their own religious beliefs. It's a tougher question, I think.
I think the question is a good one in the sense that, to Erich's point, it does speak to a trend in Supreme Court jurisprudence, and I like Elizabeth's phrase about this is sort of like the resuscitation of Lochner. And I mean, when I teach constitutional law, if you look to that era, if you look to a sort of repudiation of that era, and you look to a set of cases, as they are connected, there is a change that is happening. And so whether you look to Hobby Lobby as being, as you said, no more nuanced, I think it's about the broader issue. I think it's about a broader issue of how this court defines the scope of the power and rights of corporations, which is changing.
Well, and the next big issue, if Hobby Lobby wins, is going to be how this applies to laws that prohibit discrimination, particularly discrimination against LGBT people, because this is a big, big coming fight that's about to happen between religious freedom and discrimination protections. It is already happening, and that is something that people are watching very carefully and quite worried about.
Hoping Justice Kennedy is watching that very carefully.
And concerned about his legacy, as he is.
Yes.
Hi, Elaine Middleman. First of all, I was going to say, did you represent Mr. Cannon because you had the same first name?
It's actually the Noel Canning Company.
Okay, sorry.
Roger Noel is the...
Anyway, to get ready for today, I listened to the first 5 minutes of the oral argument last night on the Supreme Court, and it started out with Justice Ginsburg and others asking about what would happen if all the NLRB decisions don't exist anymore, and you haven't talked about that. So what's the actual effect of the decision?
So the decisions that were issued by the board with the unlawfully appointed members, so the three members who were invalidated in the Supreme Court's decision, all of those orders are essentially void. So what the board, NLRB has to do is very similar to what it had to do in a different case called New Process Steel from a few years ago, where for different reasons it held that the board was unlawfully constituted and invalidated a bunch of orders. Effectively, what the board has to do is revisit each one of those orders and decide whether or not to readopt that position.
And can it do that in the aggregate?
I think that in New Process Steel they actually assigned a panel to each case, and the panel reviewed it and decided up or down whether to affirm it, and generally I think they did affirm it. So I don't think they did it in an aggregate order.
I see. But
if they did, that might raise some due process issues.
They did it in a fairly efficient way. They didn't have to wait for a new case to arise raising the same issue.
Right.
I see.
The court decided a couple of Clean Air Act cases based on how much leeway to give the EPA in interpreting that law. And I'm curious about your thoughts on what that says about how much deference they're going to give agencies going forward, since regulatory issues are always a big question with the Supreme Court's docket?
I think that's a great question. You know, the EPA actually had a really good term this year before the Supreme Court. The initial case that you mentioned, the Clean Air Act case, EME Homer, was a big victory for the EPA. The court upheld, in a majority opinion that included some conservative justices as well, upheld the EPA's ability to regulate pollution that traveled from one state to air pollution that traveled from one state to another. That was a big victory for the EPA, and even the greenhouse gases case that in some ways limited EPA's ability to regulate greenhouse gases in one respect allowed the EPA to basically, as Justice Scalia said when he was issuing the decision, get everything it wanted out of the case. So the way that I sort of described it was that it was a 97% victory for the EPA, because the difference between what the EPA argued for in entirety and what the Supreme Court gave it, even though it limited a little bit of its authority, it was only a 3% difference in greenhouse gas emissions. So it was basically a victory for the EPA. And so it was a good term for them. And I think going forward, if you look at President Obama's promised regulations on greenhouse gas emission standards, the ruling that limited EPA's ability to regulate greenhouse gases a little bit, I don't think really will affect that provision, those upcoming standards, because it comes under a different provision of the Clean Air Act.
I think the jury's really still out on how restrictive the greenhouse gas decision is going to be on the administration's ability to regulate greenhouse gases. It's true that what the majority opinion holds is that 97% of the emitters of greenhouse gases can still be, or 84%, whatever the number was, can still be regulated by the EPA under a different set of regulations. But the majority opinion also goes at lengths to say that set of regulations has a lot of restrictions in it, and it remains to be seen whether any particular rule will survive those restrictions. And in fact, the dissenters say that they don't see how any rule could survive those restrictions in that regulatory regime. And what the majority acknowledges that, well, maybe yes, maybe no, but at least it's there, and that'll play out in future cases. So I don't really myself buy the narrative that this was a strong victory for the EPA. Maybe yes, maybe no. But I actually don't even think it was necessarily that. It could turn out to be that. But we have not yet seen how the regulations are going to be evaluated under a regulatory regime that was not the principal regime that EPA was advocating in the first place.
A last question?
Okay, Bob Saginaw. 3 years ago, there was the Schneider case where you had the picketing of the soldier and the funeral and so on. And a big part of one part of the decision by Justice Roberts was that there was 1,000 feet away, so there was a real buffer zone. So is this buffer zone idea and argument now, much less relevant, or not at all? Or does it depend on subject matter, or does it depend on how you go about the protest?
Well, it was interesting. A lot of people pointed out that the Supreme Court itself has a buffer zone, and you can't get close to the building. But I think that the two cases are quite different from each other. This was a general line drawn around these buildings that you can't even enter them, just to engage in quiet conversation that wouldn't interfere with the operations of the clinic in any way, whereas that case involved protesting and even then, of course, upheld the First Amendment challenge. So I think the two cases are distinguishable.
All right, well, please join me in thanking the panel, and thank you all for coming.